Well, after the federal government opposed the Guam Contractors Association's motion requesting for documents related to their policies and procedures and training manuals, GCA came back with their reply, asking the court to grant their motion. GCA said in their motion that they want discovery from the U.S. Citizenship and Immigration Services to determine whether the agency violated any policies when denying nearly 100% of H-2B visa applications last year. GCA demanded to inspect their internal guidance, policy memoranda, training materials, and similar documents related to issues of temporary need, peak load, and one-time occurrence. The federal government opposed this, saying the several tens of thousands of pages of administrative records for the case would be a burden for them to produce at this stage in litigation. Moreover, the federal government adds in their opposition that GCA and the other companies are not entitled to depose USCIS officials since Administrative Procedure Act record rules applies without exception. And, quote, this is a challenge to USCIS's final decisions denying plaintiffs' H-2B temporary worker visa petitions, end quote. But the plaintiffs continue to argue that the whole administrative record and policy documentation are needed to determine whether the USCIS's decisions were arbitrary and capricious, especially after prior years of approval.